with Katarzyna Sidlo of the University of Warsaw, who will speak about different understandings of Gharar and its prohibition based on the earliest sources.
I hope I'm kind of waking up with some controversy in this final paper in this conference. I'm going to speak about Gharar, and which is part of like the broad subject of Islamic finance. And most of you will have heard about Islamic finance, probably about the prohibition of interest, charging interest, etc. Not many people have heard about Gharar. And the major problem with Gharar is that although literally everyone agrees that it's prohibited, kind of no one can define it properly. We have no one definition available whatsoever. There's also a problem with the translation, so even if I wanted to give a translation to explain what Gharar is, I couldn't. Some scholars translate it as risk, but this isn't very accurate, because then you would say that Gharar is prohibited, therefore risk is prohibited in Islamic finance, which is clearly not true. So I prefer to translate it as excessive uncertainty. The reason why there's so much difficulty with defining Gharar is that the whole prohibition is based on one hadith. Well, many hadiths, but like the basic core hadith that the prohibition is based on reads Naha Rasulullah Bay'u Gharar, and that's it. So it says like the Prophet prohibited the Gharar sale, and doesn't go into explaining what Gharar sale is. So many scholars, like both in the like the early period and later on, were trying to like define or draw the lines of what Gharar actually encompasses, and what they came to can be divided like kind of three major kind of fields, if you will. So a contract will be prohibited based on its encompassing Gharar if it lacks the detailed description of the subject matter of transaction, so we don't know what we're buying or selling in detail. Or B, we lack the detailed description of the transaction itself, so we don't know the price, the time of the transaction being conducted, etc. And the third one, the most controversial one, is the non-existence of the subject of transaction. So buying is selling or what does not exist. And most of the scholars until like 12th century, including for example Al-Kasani, would say that this is the raison d'être for the prohibition of Gharar, so the non-existence of the subject matter of transaction. Other than we have Ibn Taymiyyah and Ibn al-Qayyim al-Jawziyah who say no, this is not right. This is not about the non-existence of the subject matter of transaction. It is all about being able or not being able to deliver what you sold at the time when the transaction comes to terminate. And to kind of discuss this issue about non-existence, I chose to talk about salam contract, which is future sale, meaning a sale with an on-spot payment and a future delivery. So basically this used to be an agricultural transaction. You would pay someone today to deliver, for example, wheat in 2 years' time. The wheat wouldn't exist at the time of transaction. You would have to grow it and then collect it and then bring it to you in 2 years' time. So technically, based on the definitions of Gharar, like the most wide one, this should be prohibited, because you're selling off what you don't have, what doesn't exist, and what you can't possibly describe in detail because it doesn't exist at the time when you're buying and selling it. And that's why I thought this quite interesting, and I looked into why the scholars deem this transaction salam sale, which is still being used in contemporary finance, not for agriculture purposes, but for derivatives. And what they did is they took this hadith, or a group of hadiths again, that kind of settled that salam is permissible. And the hadith, in like the most general terms, reads, when the Prophet came to Medina and people used to pay in advance the price of dates or fruits to be delivered within 2 or 3 years, he said, whoever pays in advance the price of a thing to be delivered later should pay it for a specified measure at specified rate for a specified period. So the latter part is quite clear, but the first one, when the Prophet came to Medina, kind of struck me because it kind of suggests that they didn't know it before in Mecca. So my question was to try to understand what Gharar is and how the prohibition developed, was how is it possible that in Mecca, that was the center of the trade, and I know that you've probably heard about Patricia Crone and those different discussions, but the general consensus is that the Mecca was the center of the trade in Arabia. How is it possible that they didn't know this particular transaction in Mecca and they knew it in Medina? So that's basically what I'm going to talk about and try to share with you my ideas. So in order to find this out, I went into the books of Hadith, obviously, first into the 6 canonical books of Hadith, and I looked into first of all the matn, like the wording of this Hadith, and what I've read to you is more or less like the unified structure. But also, what you should probably usually do is look at the isnad, the chain of transmission from whom to whom it was transmitted. So I looked into all those books and I took the isnads of all those separate hadiths. And what you can kind of come into conclusion is that you have 2 bundles of isnads, or 2 bundles of those chains of transmission through which this hadith has been transmitted. And then you have the, I'm not going to go into details about the hadith studies theory because it could take ages, but basically the common link theory in which when you trace the isnads of the chains, you go into this one particular person to whom you can trace it most likely to. And in case of this hadith with the permissibility of salam, we have 2 people. We have Shu'bah ibn al-Hajjaj and Abdullah ibn Najih, and also like the partial common link would be Sufyan ibn Uyayna. And the interesting part about all those people is that they've been all pupils, all colleagues of Malik ibn Anas. So clearly I went into Muwatta, different versions of Muwatta that we have in possession now. And I checked if this hadith is in Muwatta, and sure enough we can find it, and both in the Yahya ibn al-Yahya version, which is the most popular one right now, and also in Shaybani, which is probably the most different one from the remaining versions. And quite important thing to note about Muwatta is that this is not exactly a book of hadith. This is a book of amal, the record of principles, of the traditions, of what was going on in Medina at the time of Malik and before him. So what has been agreed at the time when Malik was teaching, which was around 110, 179 Hijra. Malik has been known to rely a lot on Ibn Shihab al-Zuhri. So then I wanted to find whether this hadith could have originated in Malik, or could we trace it back even further to Zuhri. Unfortunately, Zuhri's text did not survive to all the times. But lately there's been an agreement that parts of what Zuhri wrote has been transmitted through Ma'mar ibn Rashid, Namn al-Malik in Juraj, and kind of preserved in Musannaf by Abd al-Razzaq al-Sanai. And this book we have. And again, sure enough, we have the hadith with almost exactly the same wording, with the introduction when Prophet came to Medina and so on and so forth, which was transmitted on the authority of Ma'mar from Zuhri. So right now we're at the stage when we know that we can trace back, at least as early as we can, back to Zuhri, this hadith with this particular wording, suggesting that this contract has been known in Medina but not in Mecca. Now, just another hadith, which is not present in the canonical collections, but is present in Musannaf, which is again on the authority of Muhammad, but this time from Ibn Abbas, which reads, "I bear witness that God allowed an advance sale for a appointed term, for he said, O you who believe, when you deal with each other in transactions involving future obligations, in a fixed period of time, with them in writing." So effectively, he's quoting Surah Al-Baqarah, ayat 282. And now, this fits quite conveniently, because Surah Al-Baqarah is agreed mostly to be the first one sent in Medina. Sorry, the first one sent in Medina. So we do have the situation that we could imagine that the Prophet and his companions came to Medina, they found this new transaction they didn't know before, and the Surah was sent, the ayat was sent, saying, oh, it's fine, you can, as long as you write it down. And many scholars actually saw it this way, so they would permit salam based on this ayat, and they would explain that this is why the salam contract is permitted, despite the prohibition of Gharar. But the Arabic text is not very clear. You can't, you have to really interpret it, because the Arabic text says it's dain al-ajal. So it's actually debt, it's not the future sale. And sure enough, when we look into the commentaries, the Quranic commentaries, in some of them, the later ones, in Qurtubi, in Kathir, Tafsir al-Jalalain, we can see that they do interpret this hadith, this particular ayat, in relation to salam contract, and they explain this contract, the salam contract, being allowed based on this particular ayat. But when we look, take a couple of steps back, and we look into the early commentaries of Quran, like for example to the earliest one, the Tafsir by Muqatil ibn Sulaiman al-Balkhi, the earliest one that we have right now that survived, or even to Tanwir al-Mikbas. They don't really interpret this ayat in this way. They don't mention the salam contract at all. They only talk about the debt. And actually Tabari, who's like quite a good source to look into, he doesn't mention salam at all. Actually, he talks about this particular ayat, but in the context of Allah talking with Adam, the first man on earth, and they're fighting about how long Adam should live. And then, because they didn't sign a contract, they have a fight later when Adam is supposed to go to heaven and die, and Adam kind of says, no, I have 40 more years to live. So basically there was this dispute between God and Adam, and then God sent this ayat saying, well, we want to avoid this kind of disputes in the future, so we have to put everything in writing. So that's what Tabari says. So I kind of, this is still very much work in progress. This is still very much working hypothesis, so any kind of suggestion and criticism is more than welcome. But I came up with kind of three possible explanations that I'm going to share with you. The first one is that, well, there's nothing in it. There is a mistake. The phrase "when Prophet came to Medina" means nothing at all. So it means nothing at all. Either it was a mistake, it shouldn't be there, or it's just there and there's nothing to it. We shouldn't really read too much into it. The second one is that the contract hasn't in fact been known in Mecca. It was known in Medina. And the reason for it might be that Mecca was the center. So they perhaps because all those pilgrims and merchants, they came to Mecca, they brought all those agricultural goods. They really had no need to buy in advance any kind of food. They would just have it in the market because people would bring it to them. And perhaps Medinans, because their market was smaller, they didn't have a chance to do it. The third one that I'm currently working on, and I think it might be kind of explaining this whole issue, is that this contract was not known neither in Mecca nor in Medina at the time of Prophet, and it was just developed later at the time, and the first part of the 2nd century of Hijrah. So Zuhri, to whom we kind of trace it back to the Hadith as far as we can, he was known to work for Umayyads. He was helping them to kind of standardize the law, to structure the law, to kind of settle what is permitted and what's not. And we know that Umayyads, who've been residing in Damascus, they've been working quite a lot to kind of encourage the agriculture development and activity. They work with Greeks, they work with Syrians. And this kind of contract that the future said is actually present in the Roman law. It's called, forgive me my pronunciation, Emptore Sperata. So I thought maybe, the Umayyads, when they went to Damascus, they kind of served this kind of contract. They learned about it and thought, based on maslaha that we discussed before, it might be useful for the people. And it must be useful to actually use it, especially later, with Egypt becoming like the granary of the caliphate. It might be useful to use this kind of contract. And so I'm not saying it was fabricated, but maybe it was kind of developed at the time, when it was actually needed. By the time Malik was in Medina, it actually already became a custom, an amal of Medina, and people already agreed that this is something that we do. Because that's what Malik said, mostly in his commentaries. This is agreed that this is what we do, and the people of Medina would do it at that time. This would explain quite a lot of things. That's at least my theory. But like I said, this is very much work in progress, so any kind of comments are welcome, especially that I do realize that this is quite a controversial one. So thank you.